What do we expect to be taken out of the Mueller report?
So there are at least 3 categories of material that Attorney General Barr has said he will redact. One is grand jury information. So that's protected by the federal rules of criminal procedure. That's a federal statute. And it protects from disclosure, testimony of witnesses before the grand jury, and some material beyond that. But that's the core of it. So grand jury material, classified information, including information that pertains to sources and methods of our intelligence services that needs to be protected. And then in addition, material related to ongoing investigations. And we do know that there are a number of ongoing investigations that were spun off from the special counsel's probe. So those 3 areas at a minimum we know he's planning to redact.
So to get a little technical here, though, and you're in a court of law and there's redactions, you have the judge who can review the redactions to make sure that that's what's excluded and nothing else. Who's going to review it here to make sure that that's actually what got taken out?
So that's a great question. And what's particularly interesting here is that Attorney General Barr has said that he will effectively color code the redactions so that Congress will know what the basis is for redacting each part. And then they could contest that. And so I think that's what's likely to happen next, is we're going to see a subpoena from Congress to get the redacted material that may wind up eventually in a court of law for a court to rule on whether the redactions are proper.
So let's talk about the stuff that we think will not be redacted. What are we really going to be looking for based on what we've seen from that very short synopsis and what we've heard from others? What are we really looking for? Is this about the obstruction of justice issue?
Well, the obstruction of justice issue is an important part of what presumably will be in the report and that observers will be looking for. So in his short letter to Congress, Attorney General Barr said that Special Counsel Mueller had not made a traditional prosecutorial decision about obstruction of justice, that Mueller had laid out the evidence for and against and the legal arguments for and against such a charge. So we'll be looking for in this report a more fulsome explanation of what that evidence was for and against an obstruction charge against the president.
So what does that tell us? I mean, he was willing to make that prosecutorial decision when it comes to collusion, as I understand it. Said, no, there's no evidence. I wouldn't prosecute on that. He said, on this one, I'm not going to make that decision. There may be some evidence for, some against. Why is he making a different decision about that?
We really don't know that. It's one of the things that's been most puzzling to those of us who've been thinking about this for a long time, is why didn't he make that decision? Did he anticipate that Congress effectively was the proper forum in which that decision should be made about whether this was an impeachable offense? And in addition, he thought, I think, that the law perhaps was a little bit less clear about what would be obstruction of justice when it's the president of the United States who sits atop the executive branch, making certain decisions and directing subordinates, for example, to drop an investigation with respect to Michael Flynn. That's different than the activity that happened during the campaign when now President Trump was candidate Trump.
So Thursday we may know the answer to this question, but let's speculate for a moment. Is it possible that Mr. Mueller said, you know what, I don't think I can indict a sitting president, and so it's academic. I can decide that I wouldn't have indicted even I could with respect to collusion. On this one, there may be enough there, but I think as a matter of law, I can't indict a sitting president, so I won't make a decision.
We might see some discussion of that, although in Barr's short letter, he indicated that the decision was not based on that legally problematic question. But there may be something in the way that it's presented by Mueller, if we get to see it, that indicates whether that was in some way in his thinking.
So let's talk for a moment about Attorney General Barr, because up in front of Congress, he referred to spying, that he was going to investigate, because he thought spying had gone on. He's going to investigate the investigation, which presumably includes the FBI, as well as maybe the Justice Department and other people. What is that about? I mean, what is the line between spying and just normal law enforcement surveillance? I mean, you were in law enforcement.
Yeah, so it's not exactly clear what he was referring to there, and he went on to clarify later during his testimony that he was talking about surveillance that was not warranted or supported by adequate facts and law. If you do, for example, a wiretap on somebody, you need to get a court order to do that. And so if you don't get that wiretap approved by the court, that is unauthorized surveillance, and some might colloquially refer to that as spying. But spying is not a legal term of art.
But there's a big difference, isn't there, between a warrant that's been issued, maybe it shouldn't have been issued, maybe the judge made a mistake on the one hand, and on the other hand, doing something without a warrant. If a warrant were issued, inclusive by a FISA court, for example, doesn't that really protect the FBI, the prosecutors and things like that from any sort of retribution? Yes,
absolutely. I mean, that's why you go to the court, to get the authorization. And that's why I say it's not clear what he was talking about and why, in fact, I think he walked back those comments. What he meant to say, as I understand it, was that it's possible that there was surveillance that wasn't warranted by the facts and perhaps wasn't authorized by a court. But he also said that he didn't have any particular evidence to back that up. And that's part of why it's disturbing that he made those remarks about spying. Really, one should wait for the evidence first and do the investigation before offering a conclusion that there was spying.
And one last question about Greg Craig, a somewhat different subject, but a well-known, respected criminal lawyer, came out of Williams and Connolly in Washington. Now he has been indicted, actually, for violating, as I understand it, the foreign agent laws in Washington. What is that about? I mean, are those laws just so difficult to comply with?
Well, the truth is that the charges that have been brought against him are actually about lies that he made to Department of Justice officials about his activity on behalf of Ukraine. So they're not actually so much about the unlawful activity under FARA, but about the statements that he made to those who were investigating his activity on behalf of Ukraine. So in a sense, he's been charged with far simpler crimes of making materially false statements to investigators.
But it's one thing if Martha Stewart goes in and talks to authorities without a lawyer present, which we all think is a pretty bad idea. Greg Craig is a really good lawyer. I mean, isn't it passing strange that he would make that mistake of committing perjury, essentially lying? I guess it's under, what's it, 18 U.S.C. 1001.
That's one of the charges. Yeah, there are two.
Is that right?
There's one that is more specific to the FARA-related entity of DOJ. Yeah. So it is an extremely unusual case, and part of what's so unusual about it is that it has essentially been bounced between different DOJ offices from the Southern District back to D.C. now.